and the federal footprint, the FBI footprint in this case, is beyond anything we've ever seen. And I say that because of the 68 terabyte dump right before trial to the defense, in which it was unindexed. There was no way of searching it. Search it for years, you're probably not going to get it. You're going to need a vast team to go through it.
68 terabytes dropped on the defense just weeks before trial, with no way to index it or possibly review it. That would be extraordinary. But is that what actually happened? Or have we been told a story about 68 terabytes, echoed by creator after creator, that simply isn't based on facts? There are 3 questions we need to answer in this video. First, is 68 terabytes really unprecedented in a court case, as Big Amish says? Second, were 68 terabytes actually dropped on the defense just weeks before trial? And third, did the defense really have to manually process all of that data? Let's start with the first claim. Now let's be clear about something. 68 terabytes is a lot of data. No one needs to minimize that. But a lot and unprecedented are 2 very different things. And we don't even have to leave Idaho to find an example. In a federal criminal case, United States versus Alon, the U.S. District Court for Idaho described search warrants that produced more than 75 terabytes of evidence. So before Mr. Kohberger's case ever existed, an Idaho federal court was already dealing with a criminal prosecution involving a larger volume of digital evidence. And the numbers get considerably larger when we look at civil litigation. In the Volkswagen emissions litigation, attorneys told a federal judge that approximately 100 terabytes of data had been made available to the law firm conducting Volkswagen's internal investigation. In litigation involving Amazon and the Federal Trade Commission, Amazon told the federal court that structured data sought during the FTC's investigation totaled more than 100 terabytes as well. And in a federal civil rights case in Texas, defendants told the court that the discovery being requested amounted to approximately 150,000 documents, 14,000 hours of video, and 75 terabytes of data. So 65 terabytes enormous? Absolutely. Is it unprecedented in litigation? No. But that actually isn't the most important problem with this claim, because the size of the discovery doesn't tell us when the defense actually received it. And that brings us to question number 2. To answer that, we don't have to speculate. We can go back to what Ann Taylor herself told the court. On January 26, 2024, more than a year and a half before the scheduled August 2025 trial, Ms. Taylor told Judge that the defense was already dealing with 51 terabytes of discovery.
This court knows everything is recorded. There's digital footprints all over the place. And so we have a lot of records that we have to go through. I know that the court has heard about 51 terabytes of information that we've received. And I want to tell you what that means. Ms. Massa found a statistic for me. And I want to tell you how much 51 terabytes of data is. And
51 terabytes in January of 2024. So right away, the idea that 68 terabytes suddenly appeared just weeks before trial doesn't fit the documented timeline. And this wasn't even the beginning of discovery. Mr. Kohberger's defense filed its original request for discovery on January 10, 2023. The state responded on January 23rd. By February, the defense was filing supplemental discovery requests. More followed in March of 2023, May, and June. And that process continued throughout the case. By May 2024, the prosecution was already on its 25th supplemental discovery disclosure, including cell site data, tower logs, and other digital tracking evidence. By the September 2024 general discovery deadline, the state had also produced thousands of police reports and crime scene photos, along with more than 9,200 community tips. Additional search warrant material followed in November, guilt phase expert evidence in December, and penalty phase expert disclosures in January 2025. So this wasn't a single data dump, it was rolling discovery. I'm not an attorney, but that's actually not that unusual. Ms. Taylor reported 51 terabytes in January 2024, and by December it had grown to 68. And in March of 2025, the defense said it had already spent more than 2 years working through the data. That's the timeline, not weeks, years. Now, none of this means that the defense received everything early. They didn't. There were motions to compel, and the defense complained about how some of the material was organized and about how information it believed was still missing. Those are legitimate issues, but they're not evidence of a 68 terabyte data dump weeks before trial. Which brings us to the third claim. No, modern electronic discovery isn't reviewed by opening tens of thousands of files one at a time. And we know the Kohberger defense had tools available to organize and search electronic evidence. Idaho's public defense system uses LegalServer, an electronic case management platform where discovery can be stored, organized, indexed, and searched. LegalServer isn't just a place to store files. Its document management system supports full-text search and indexing across case files, allowing attorneys and investigators to search large collections of evidence quickly. And modern e-discovery platforms can use automated and AI-assisted tools to rapidly process and surface relevant material from datasets, including video. We don't know exactly which of these capabilities Ms. Taylor's team used, but we also can't pretend that the alternative was an attorney sitting in front of 68 terabytes of files and opening them one at a time. And there's something else in the court record that's even more direct. When the defense requested the contents of an FBI shared drive, the state said those materials were provided with a searchable index. So was reviewing this much evidence an enormous undertaking? Of course. This was a capital case. The defense had every reason to be exhaustive. And 68 terabytes is an enormous amount of data. But enormous undertaking is not the same thing as no way to index and process it. And that's the distinction that keeps disappearing when this story gets repeated. So let's go back to our original three questions. Is 68 terabytes unprecedented? No. Other cases have involved 75, 100 terabytes or more. Was it dumped on the defense week before trial? No. Ms. Taylor reported 51 terabytes in January 2024, and the defense later said it had been working through the evidence for more than 2 years. And did they have to process it all manually? Again, no. They had electronic tools to organize, index, and search the evidence, including the video evidence using AI. But take a massive number, erase the timeline, ignore the technology, and repeat the claim often enough, and 68 terabytes of discovery becomes a 68 terabyte data dump just weeks before trial. Those aren't the same story, and only one of them is supported by the record. If you like my videos and how I present the information, please subscribe and like the video.